The Federal High Court in Port Harcourt has issued an order restraining the Federal Inland Revenue Service, FRS, from collecting value-added tax, VAT, and personal income tax in Rivers State. Here to speak on what the recent judgment is all about and how this will affect states going forward is partner, Tax Advisory and Regulatory Services at Andersen Tax, Michael Ango. You're welcome, Michael. Good morning.
Good morning.
Good morning. Good to have you on the show.
Morning, Michael.
Yeah.
All right. It's a landmark judgment, isn't it? Tell us what your thoughts are and how you think this will affect, on the one hand, the revenue drive of the federal government, and on the other hand, for Rivers State and every other state, since the judgment says that, what has been delivered is applicable to all the other states apart from Rivers State. How will things take shape going forward?
All right. I think when you say it's a landmark judgment, it is indeed a landmark judgment, but not so landmark. Interestingly, in 2020, December 2020, a Federal High Court in Rivers State, in the case of Ocala versus the Federal Inland Revenue Service, had pretty much said the same thing that this decision said. It essentially said that VAT was an item that was not provided for in the exclusive legislative list of the Constitution, and thus the federal government did not have the right to collect VAT. So that decision was, I think it was understated, probably because it was an individual that challenged it. So this challenge coming from the Rivers State government is getting a lot of publicity because I think this is a state now challenging the powers of the federal government to impose value-added tax across the states. So to that extent, I will say that this is a decision that had been coming. A bit of a historical perspective might be useful here, simply because, these issues relating to the powers of the federal government and the state government has been an issue that has been recurring from the 1980s. We've had, sales tax challenges as far back as the 70s, where we had the Attorney General of Ogun versus Aberiogba case, where the Supreme Court essentially held that the sales tax law of Ogun State was invalid. Scroll down to the 2000s, where we had, of course, the Echo Hotel case, where the Supreme Court essentially held that, the federal government had covered the field in terms of sales taxes by enacting the value-added tax, and thus states could not collect any sales tax, in the states. But interestingly, in 2019, we had a case in Lagos State where a federal high court said that the Lagos State hotel consumption tax was valid, and that indeed, value-added tax isn't provided for in the Constitution, and thus, where a state has enacted a sales tax or a consumption tax law, that law covers the field, and that, it's under the residual powers of the states. So that's really the background to this case, and in terms of impact, certainly this case has a significant impact on revenue for the Federation, not just for the federal government, because you must look at it from the perspective that the value-added tax that is collected across the Federation is essentially shared by the federal government 15%, the states take 50%, and the local governments take 35%. So essentially the states take 85% of that collection. Of course, there's also the argument that the federal government keeps a 4% cost of collection, which is held back by the Federal Inland Revenue Service. So that's probably about 19%. But give or take, the states at least take the larger chunk of the revenue. So I don't know what will happen in the short term, but certainly a lot of changes will occur if this decision is upheld on appeal. But I know that the Federal Inland Revenue Service has appealed the decision, so we'll wait and see what happens from then on. But if things remain as they are based on the judgment, it simply means that states will then be responsible for collecting sales or consumption taxes within their borders. And let me just clarify. So there's been a lot of commentary in terms of saying that states can collect VAT. So I don't think that's the correct reading of the decision. The correct reading of the decision is that the federal government cannot collect VAT, and that VAT as it is constituted today is unconstitutional. So the correct reading will be to say that states can now enact their laws within their borders to replace the value-added tax and then collect whatever tax they want to term it, whether it's sales or a consumption tax.
Understood. But it's not just VAT that was up for discussion or involved in this judgment, wasn't it? It was VAT in addition to education tax and other ones like that. What role do those different taxes play in this scenario?
Very good. Thank you for bringing that up. And that is interesting. And you see, so again, we're being a bit cautious in terms of how we're commenting on the decision, because as we speak, no one has a copy of the certified true copy of the decision. And I would have expected that given the importance of that decision, the court would have hastened to make it available. But what the court also said, in addition to the fact that the federal government could not collect VAT, is that for the technology levy collected by the FRS on behalf of the Information Technology Development Agency, and withholding taxes, education taxes, and personal income tax, it said all of these were under the purview of the state government. Now, I really don't see how you could stretch the. So I think it's really based on item 59 of the second schedule, which says that the federal government or the National Assembly can only make laws to tax incomes, profits, and capital gains. So I don't know on what basis the judge would have said that the federal government cannot collect the technology levy and the education tax. But for the withholding tax and the personal income taxes, these have already been under the purview of the state. So personal income taxes paid by individuals and withholding tax, on the individuals has always been collected by the states. But for the technology levy and education tax, tertiary education tax, I really wonder what the basis for the decision is. Having said that, it's really about our fiscal federalism here. I think it's really states again trying to push the envelope and say to the federal government, look, it's time you allow us to do what we have to do to improve our financial status. Whether it will be welcome across the federation is a different question, because you and I know that states have different economic and commercial activities within their borders. But certainly it's a conversation that needs to be heard now. It is before the courts, and so some have said, look, let's allow the courts discuss it and find a solution. Some other people have said, maybe we need to have, in Nigerian parlance, a political solution to it. But whatever be the case, I think this is a journey that has started, and it will certainly have to terminate one way or the other. Either the states will expand their taxing powers, or the federal government will continue to retain this control that it has over a lot of tax items in the Constitution, and of course, under the Taxes and Levies Approved List for Collection Act, which is another act, incidentally, that has been controversial, because it's an act that essentially expands on the constitutional provisions and says states can collect these items, local governments can collect these items, and the federal government can collect these items. And there have been challenges to that particular tax act. That's the Taxes and Levies Approved List for Collection Act. And in fact, the court has actually, declared that same act invalid. So again, these are all discussions that are taking place. And I think for us, we're living in interesting times. It's really interesting to see that after all the talk about fiscal federalism, now people are putting their money where their mouth is.
Very well said, Michael. I totally agree with you that this is about fiscal federalism. I know for a fact that Lagos has always tried to challenge many things in court, and has won a few cases against the federal government. I followed in 2019 very closely the ruling, the judgment that you referred to between the Lagos State government and the trustees of the hotel associations regarding the consumption tax, which, as you said, premised this very ruling that Rivers State has gotten. If this is retained on appeal, and eventually maybe there will be a pronouncement later, at the Supreme Court, and the states win, ultimately, will that lead to a situation where federal government can determine what VAT, not just collecting, but determining what VAT you pay, raising the amount from 5% to 7.5%, etc.? Are we likely to go into a kind of American situation whereby states determine what VAT you pay and how VAT is collected? Okay,
can we just try to not use the term VAT in terms of what the states will collect? So I know VAT has been with us for 30 years or thereabout. So it is a tax on consumption. Okay, so it's termed value-added tax because that's what it was termed in the act. But in the U.S., for example, each state has its sales tax. In some other jurisdiction, it's called a goods and sales tax. But I mean, you are right. once this decision, if rather it is upheld on appeal at the Court of Appeal and subsequently at the Supreme Court, what it simply means is that the federal government has to hands off. Okay, has to hands off completely in terms of collection of VAT, let me use the term, or sales or consumption tax across the state. And certainly if it doesn't have the power, it means it cannot determine what the rates are, it cannot determine the collection mechanisms, and of course it cannot determine how the amounts are shared or collected by the states. What will then happen, in theory, of course, is that each state will then enact. For those who already have, they will probably try to expand it. Lagos, as you were, already has the hotel and restaurant consumption tax. And then states like Rivers, maybe Ogun, wherever they want to implement the decision, will then enact their sales or consumption taxes and then set a rate for it. The one challenge that people or commentaries have pointed out is that we may then go back to this old issue of multiplicity of taxes. So where items are sold and then moved from one jurisdiction to another, there will be the challenge of having, you pay the tax in Lagos. If you move to Ogun, you pay it in Ogun. If you take a plane and drop in Port Harcourt again, you will pay it in Port Harcourt or Rivers State. But these are all issues that can be ironed out. The reality is that, the states have always believed that the federal government has been unfair to them in terms of the revenue sharing formula. Whether that is wrong or right is neither here nor there. But the reality again is that the states have always clamored for more leg room in terms of what they want to collect. Whether they will collect it as efficiently as the federal government is doing is another question. And we must also remember that, like I said, the economic activities in some states are not as significant as those in some of the other states. So what happens in those other states, will they then still go back to the federal government and say, please, can you augment my revenue? Or will they try to be creative in terms of seeing what they can tax? So like I said, these are interesting times. Let's wait and see what happens. Certainly, there has to be a pronouncement one way or the other on appeal. And I see this case going up to the Supreme Court. And when the Supreme Court makes a decision, we can then come back here and analyze that decision.
Understood. I mean, in the meantime, I wonder if you think that this decision will reinvigorate any type of North-South divide, because as it stands now, it does look as though states like Lagos, Ogun, the FCT, and indeed Rivers are the biggest contributors to VAT, and that those monies help other states across the country with their own, I'd imagine, revenue practices. Do you see this quote-unquote win as one for southern states, one where they are able to now more carefully control the amount of money that they generate and keep it within the region?
Well, unfortunately, I'm just a tax consultant who analyzes the tax laws and advises my clients. I have clients from north, south, east, west. If there are clients under sea, I would also try to have, those clients engage me. But I understand what you're trying to say. Honestly, I don't think we should look at things from those kind of prisms, because at the end of the day, every constituent of this country, every state, every local government has some comparative advantage that it can mine. And so for me, really, it's to say to us, this is the time to roll up your sleeves and be creative. It might look like it's skewed in favor of one part or the other, but the reality is that every part of this country has something that it brings to the table. Possibly, reliance on the federal government has made certain parts of the country, feel a bit too comfortable or laid back. And maybe this kind of decision will then make us all, wake up. Because, I've traveled across the entire country, and I can tell you that there's no part of the country that has, a better opportunity in terms of raising of taxes based on whether it's population or economic activity than another. We all have our comparative advantages. And so for me, that's the message that really should go out pending whatever decision is taken. It's one country, and I think we should all see ourselves as one country, and then we're all trying to make our lives better, whether you're in Sokoto or you're in Calabar or you're in Enugu, wherever you are. The most important thing is that government should raise revenues and use those revenues for the betterment of the people within the areas where those revenues are raised. That's the most important thing.
Okay, what sort of signal, therefore, do you think that this judgment must have sent to the FRS in particular, given the times that we are in? We see a federal government that is looking for money at all costs, aside borrowing. Lately, we've heard about, trying to return to tolling you know, on the highways, etc. The federal government had even toyed with the idea of borrowing from pension fund. Given that FRS is probably one of the largest revenue pools for federal government, what do you think the sort of signal that this must have sent to them? Will they be a lot more creative now if we eventually get a pronouncement as to FRS and the federal government handing off sales tax and consumption tax and, you know, VAT, etc.? You know, how should they prepare for the future?
I think on this issue of VAT, the one criticism I may have of the Federal Inland Revenue Service is that they could have been a bit more proactive. Proactive in the sense that this is an issue that was always coming here. It had been brewing, and I think after the decision in Ukala's case in December 2020, I think the FRS should have then probably called a meeting or tried to call, engage with stakeholders across the entire country and say, look, listen, while we understand your concerns about value-added tax, show them the figures. Value-added tax was 1.5 trillion last year. Show them that, look, we are best positioned to collect this thing on your behalf. We're more efficient. We have better facilities. We're spread across the country. But you're right, FRS has to be creative. Now, creativity doesn't necessarily mean creating new taxes in terms of, you know, whether it's tolling or on all of that. The federal government, yes, has tried to, you know, look for revenue in all sorts of places. The pension funds, like you mentioned, the unclaimed dividends and bank balances, you know, and all of that. Unfortunately, these things have been challenged in court. The unclaimed dividend trust fund has been challenged in court, and it's pending now. It hasn't taken off. For the FRS, there has been the electronic money transfer levy that was introduced last year. I don't know how far that has gone. But I do not think that the solution to raising revenue is really creating new revenue heads. I think it is about being more efficient in terms of bringing in all the taxpayers that should come into the tax net, and more importantly, collecting every kobo or every cent, as it were, that should be collected in terms of tax revenue. There's no tax revenue system in the world that is foolproof. But I think that if we look at our tax collection compliance in Nigeria, globally we're set to have maybe a 6% tax to GDP collection ratio. That is extremely low. And so we need to really work hard. Of course, it's not just for the FRS. You know, the state governments too have to do some work in this. They have to put in the shift. And then collaboration. That is really the key word. At the end of the day, like I mentioned earlier, it is one country. And so whatever happens in one place may affect another. But certainly we will see some reactions. Whether that reaction will come in terms of introducing new taxes or just trying to be more efficient in tax collection or trying to be carry stakeholders along more. It could even lead to the federal government probably proposing a change in the revenue formula as a means of assuaging the state. So we don't know. We'll wait and see. The Finance Act 2021 is being drafted at the moment. We're part of the team that will look at it when the FRS and the Ministry of Finance brings it out. So, of course, we'll be able to look at these things and advise them. And maybe let me commend the FRS in terms of the engagement with consultants. You know, they've actually been useful in that regard. They've always exposed what they want to do to us, and we've been able to give them our opinions, even if they don't always take it. But this is one way to go. So maybe what they then need to do is to expand consultation to the states and ensure that the states are also brought in and they open the figures for them, let them see what it looks like, and probably this would then help to be assuage certain concerns across the states.
Understood. Michael, I'm hoping you can clear something up for me. I know in the early part of our conversations, you said that this judgment isn't final. There's still definitely grounds for an appeal, yes, and challenges and thereabout. Is this a situation that could go upwards to the Supreme Court? I ask because I was looking at an article and it did say that when it pertains to cases involving federal tax collection, it is in fact rather the Federal High Court that can handle those things, not the Supreme Court. I was wondering if you could clear that up for me. Does the Supreme Court clear up issues like this?
Okay, so let me explain what the article meant to say. What the article, I haven't read it, but what I think the article is simply saying is that the Federal High Court has original jurisdiction. Okay, so if I have a dispute on a federal tax item, of course, there's also the Tax Appeal Tribunal, but that is an inferior tribunal to the Federal High Court. So the Federal High Court is the court of first instance in this regard. When you go to the Federal High Court, just as the Rivers State government has done, and then you've laid your complaints at the Federal High Court, the Federal High Court has given a ruling. You can then appeal to the Court of Appeal and up to the Supreme Court. And the Supreme Court, as we know, is the final court in the land. So ultimately, if there is going to be certainty in this regard, it has to get to the Supreme Court. Except again, like I said, if we then seek a political solution, quote and unquote. What that political solution would look like, I don't know. And again, it will then depend on whether the Rivers State government wants to sit back and say, okay, even though I have this judgment, I will not implement it. But otherwise, you have to go to the Court of Appeal and ultimately the Supreme Court and get a decision. There's one window, and I'm giving free advice here, which is to get a stay. You can get a stay of execution. If you then get a stay of execution, it then means the status quo will continue until such a time that the final court decides. Other option is to go for a constitutional amendment. That's an option. How that will happen again is a big challenge, seeing that you will need 24 states at the minimum to get a constitutional amendment passed through. But certainly, one way or the other, this issue has to be decided. It has to be resolved. How it is going to be resolved is what we cannot predict now, but we'll wait and see.
All right, Michael, that's a good one. But very quickly, while we're rounding off, what sort of advice will you have for startups and small businesses, those who encounter tax consultants who work on behalf of the FRS or the state tax agencies, every now and then, bringing up different, issues. How do you think, because you mentioned the fact that, yes, FRS has been collaborating, even if they do not always take your, advice and suggestions. But what will be your advice to, young companies who are not dealing directly with FRS or LRS, as the case may be, but those intermediaries who come on their behalf to collect taxes?
Well, so if I understand what you're saying, it's the issue of use of, is it consultants in tax revenue collection?
Yes.
Yes. Again, okay, yeah. So the reality is that this is an issue that I honestly think should be discouraged. Because ultimately what is important is whether the Federal Land Revenue Service or the state boards of internal revenue, they must build their capacity to be able to collect their taxes directly. As we've seen in some of the states, it's been done successfully. So I think what will happen, my advice, interestingly, I advise a number of startups in terms of their tax compliance and entry into market. The reality is that startups are, usually come into the market and they don't have full information about what their tax obligations are, and some of them make mistakes early enough, and it is those mistakes that are usually capitalized on by the tax authorities who are just looking to make revenue. When you hear that maybe a Flutterwave or a Paystack has been acquired for X million amount of dollars, so you think it applies to every tech company, but it's not always that way. So I think what the advice is always, get a consultant who knows what the laws are, who has competence and also who has integrity that can advise you on how to navigate your way. As for the state governments, we always advise them to say, look, even if you want to use consultant, let this be for a limited period. Let it be about capacity building and some technical input, but do not use consultants to do the routine things like, collection of taxes and audits. I feel that, that is not the place of consultants. The consultant should be someone who advises, who comes in with a specialized skill that may not be present at that time. And ultimately, that skill or expertise should be devolved or cascaded to the tax authorities so that they can then take it on from there. Otherwise, we'll see a situation where consultants will just be embedded within the revenue authority for hundreds of years, and they'll be collecting commissions on issues that can be properly handled by the tax revenue authorities themselves. So, for startups, I'll say, tech startups, I'll say come to Anderson Tax, and then we'll help you navigate the landmines of
there we go.
Of the Nigerian tax system.
Michael Ango, who is a partner in tax advisory and regulatory services at Andersen Tax, thank you very much for joining us this morning. Wish you a very good rest of your day.